Hi guys, welcome to Commercial Law Tutorials, Law of Property. We have already looked at the definition and the requirements, classification of things, possession, as well as the definition, acquiring, and the forms of ownership. Today we are moving on to lesson number 5, protection and the extinction of ownership. In this lesson, we'll look at the general rule, then protection of ownership, extinction of ownership, and at the end of the lesson, I'll give you popular exam questions relating to this lesson. But before we look at the general rule, let us define what ownership is. Ownership is the sum of all possible rights in a thing. That is the absolute, full and complete right of dominion over property. It is the legal right to the possession of a thing. It is the independent, general right of a person to control a thing he possesses, subject to no restrictions except those that are imposed by public and private law. So when one owns a thing, he has absolute ownership. When one has absolute ownership, he has the right to use a thing and enjoy its fruits, right to exclude others from using the thing, right to dispose the thing, and also the right to destroy it. That was ownership. Now let us look at the general rule regarding ownership. An owner cannot be deprived of his property. No one can transfer ownership of a thing which he is not the owner of. That is the general rule. So neither a thief or any other person can transfer the right of ownership to another person. It does not matter whether the one who is acquiring ownership from a thief or a hirer or a bona fide possessor is acting in good or bad faith. Ownership cannot be passed. We have few exceptions though, like judicial and municipality sales. In these cases, ownership can pass. Protection of ownership. How is ownership protected? The protection of ownership is done using real remedies, delictual remedies, and enrichment action. Real remedies are those that protect the owner's title to his property by removing any infringement on his entitlements, or they also restore physical control of the property to the property owner. These are the real remedies we have. Then delictual remedies. Delictual remedies are there to compensate the owner for damages due to loss resulting from unlawful and culpable actions by others. These are the delictual remedies we have. Then, enrichment action. It provides for the compensation to the owner due to the use and consumption of the property of the owner. Let us look at this in detail. We'll start off with vindication. Vindication is the claim made to the property by its owner. The owner who is out of possession of his property sues to recover possession from the person who has that property. The owner of the property can vindicate it from any person who is in possession of it, whether the person who has the property is a bona fide or a mala fide possessor. It doesn't matter. Or when also the owner had given possession of the thing to another person by lending, hiring, or by lease, who then had alienated it to the defendant. The owner can vindicate that thing. For one to claim under vindication. He has to prove that he is the owner of the property. Then the property was in possession of the defendant when legal action commenced. There are exceptions or restrictions to the power to vindicate. Money and negotiable instruments cannot be vindicated. One can never get the exact notes he had, as this would disturb the whole flow of money. Then property sold in judicial sales cannot be vindicated also. Then we have ACTIO ad exhibendum. This is when the owner of a thing asks the defendant to produce the thing in his possession. If the thing cannot be returned to the owner, the value of the property is claimed by the owner. Failure to return the thing to its owner can be due to sale, consumption, destruction of that thing by the defendant. So, this is when the value of the property is claimed by the owner. Being given back the value of the thing or property is all what this action is all about. Then we have CONDICTIO FURTIVA. It is an action which arises when a theft occurs. The owner through this action would be having the intention of recovering the specific stolen thing or property or its value from the thief or the thief heirs, together with the fruits of the property which has been stolen, if there are any, from the time the thing was stolen. Then we have ACTIO LEGIS AQUILIAE. It is a claim of damages for the harm, damage, or destruction caused to the owner's thing. The owner claims compensation for patrimonial damage he suffered due to the defendant's wrongful act and possession of that thing. This action is all about compensating for damages on the property. Then we have ACTIO NEGATORIA. It is used by the owner of a land who seeks to prohibit some ongoing nuisance or trespass on his land. It is an action in rem. It is the action for the recognition and enforcement of a servitude that permits the owner of a land to resist or deny the existence of any alleged servitudes on that land. For instance, construction made over the border of his land. That was all I had for you. Let us look at extinction of ownership. How is ownership in a thing terminated? Transfer of right of ownership to another person terminates ownership in that thing. When thing is destroyed, abandonment of the thing with the intention that it should become a res nollis. Destruction of property in public interest, for instance, demolition of a house which is against the building regulations. Then, law itself, by operation of law, ownership can also be terminated using the following: acquisitive prescription and accession, insolvency of the owner, attachment and sale in execution, forfeiture and confiscation, expropriation. Those are the ways in which ownership can be terminated by operation of law. Let us now look at the questions. What are the ways used to protect ownership? In what ways can ownership be terminated? In what circumstances is ownership terminated by operation of law? Thank you so much for watching. Remember to subscribe and like if you haven't done so.